Good evening. A very warm welcome to Monash Law Chambers, the home of the Faculty of Law at Monash University in the heart of Melbourne CBD. For those I've not met, I'm Stephen. I'm the Dean of the Faculty. Tonight we are talking about justice and about law and lawyers in relation to advancing or threatening justice. And those matters and those topics should cause us to reflect on the histories of these lands on which we meet, the unceded lands of the people of the Kulin Nations, and how law and lawyers have been at different times and in different ways, both agents of oppression and catalysts for positive change. I pay my respects to elders past and present, and I extend those respects to First Nations guests with us tonight and listening online. Let me start with some brief introductions, and then I'll speak to the format. We have a panel of 4 speakers. 2 down from me here is Fiona McLeay, chair of the panel for this evening, CEO and commissioner of the Victorian Legal Services Board, also co-chair of Equality Australia. Fiona was the former CEO of the Access to Justice organisation Justice Connect, a lawyer by training. She's previously been General Counsel and Company Secretary at Well Vision Australia and Special Counsel at Clayton Utz. And I'm grateful to Fiona for helping me pronounce that law firm's name correctly now for the first time in my 6 months in Australia. Richard Moorhead, to my right, is Professor of Law and Professional Ethics at the University of Exeter in the UK. He arrived yesterday at 1 o'clock, so we'll be kind to him if he's not as dazzling as usual. He is one of the world's leading voices on legal ethics, access to justice, and the role of lawyers in society. He has secured over $6.5 million in research income. He's advised governments and regulators. He gave the Hamlin Lectures in 2024 and has led a series of major research projects with real-world impact, including on the Post Office, the topic for this evening. Also, and as of today, Richard is the newest Professor of Law inside the faculty and will be splitting his time between Melbourne and the UK. Next to Fiona is Associate Professor Yee-Fui. Her research centres on strengthening political institutions and enhancing executive accountability. That research is repeatedly recognised by the High Court, the Federal Court, and by Parliament. She is a 2022 Fulbright Scholar, the 2023 winner of an award from the Vice-Chancellor for Research Excellence, and her latest book, Combating the Code Regulating Automated Government Decision-Making, was published this year by Cambridge University Press. Today is also Yee-Fui's birthday. And I'm told that there'll be a multi-part harmony of a happy birthday song by the audience at some point. I'm very grateful to all of you for organising that.
Such is my commitment to miscarriages of justice that I am celebrating in this way.
We are very grateful. Next to Yee-Fui is Associate Professor Joel Townsend. As many of you know, he has a long history of contributing to the work of the community legal sector. He is Director of Monash Law Clinics, one of the primary vehicles inside the faculty for how we provide free legal advice and assistance to the Victorian community. Prior to coming to Monash, he spent 15 years at Victoria Legal Aid as a practitioner and a manager, largely in the civil justice programme. He's vast experience in public policy matters, including, as we'll hear tonight, in relation to robo-debt. So in terms of our format, Richard will begin with a short lecture about the Post Office scandal in the UK before we move over to that panel format chaired by Fiona. We hope there'll be some time for audience Q&A, and then there will be drinks and nibbles from 7 p.m. I've said nibbles, there may just be drinks. There'll be something at 7 p.m. If there are not nibbles, I'll go out and buy some peanuts. Okay, thank you. Over to Richard.
Thank you, Stephen. I'm delighted to be here. We didn't plan that this would be my first day working at Monash. It just sort of happened that way. I have been working all day on my first day after arriving at 1 p.m. yesterday. But nonetheless, it's been fantastic. I really am delighted to be here. It's a wonderful way to mark joining the law school. I'm going to talk, as Stephen said, about the Post Office scandal. I lead a team. That's not working now. Because I didn't turn it on. Jet lag. The first of many excuses. I lead a team funded by our Economic and Social Research Council researching the scandal with doctors Day and Noakes, Professor Howman, Paul Gilbert. Paul is a former general counsel, and the team brings expertise in law, professional ethics, psychology, and criminology to our analysis. To try to answer how do lawyers contribute to miscarriages of justice, I'm going to very briefly sketch for you the Post Office story and provide some analysis along the way of what might be driving the problems. But to provide a high-level overview, I would say one of the problems is this: engaging in what I call legal aggression, that is arguably legal but probably unlawful and or misleading representations of law and facts. And that's rather different from what we sometimes call creative compliance, and slips into what I also call legality illusions, improperly implying that something is legal or true or sometimes even just when it's likely or highly likely to be the exact opposite of that, typically untrue or illegal or unlawful. And done knowingly or recklessly, that is, or is usually, professional misconduct, which is why I'm interested in it. Here's a legality illusion from the Post Office scandal. This is the Post Office CEO from a crucial period of the tale. She told a government minister in writing that there was nothing to suggest any conviction was unsafe. Nothing to suggest any conviction was unsafe. And of course, there was such evidence. There was actually plenty of evidence. And yet the lawyers working in her organisation and instructed by her organisation helped construct this line, misleading at best, untrue in essence. You could quite easily say it was a lie, although she might not have known it for reasons which we could talk about later. Why this happened is a product of legal and corporate cultures, individual and organisational, incompetence and professional complacency. Indeed, I might say systemic complacency within the law, which extends beyond the lawyers themselves. And I'm going to try and explain all of that in the next 15 minutes or so. So, the story. The main period of the scandal ran from 1991 to 1999 to 2021, over 20 years. It's still running, arguably. And until at least 2013, the Post Office had been claiming for phantom debts created by its electronic point of sale system, its electronic till, and accounting system called Horizon. The debts were often caused by system errors in the computer program and in its operation. Post officers told postmasters to pay those debts. And if they wouldn't, or they couldn't, often the debts simply got too big for them, the Post Office threw them out of the Post Office businesses, sued them, or often prosecuted them for theft, fraud, and or false accounting in different combinations. About 1,000 people were prosecuted and over 200 went to jail. Livelihoods were lost, lives were ruined, the effects on victims, economic, physical, social, and mental, has been extraordinary. We've documented and measured some of those on the project. Lawyers contributed to these miscarriages of justice in many ways. I'm going to talk you through a number of phases. The first of these is drafting unfair contracts and enforcing them, sometimes misleadingly, and sometimes to make examples of people to discourage others from taking on the system or the Post Office. But the main way was prosecution, mainly, but not only, private prosecutions brought by the Post Office itself. And they were brought with key evidence missing. Typically, theft was charged without evidence of dishonesty and without evidence of appropriation of money beyond the computer record itself, which was prone to error. And conviction for theft meant prison. And so the Post Office knew they could pressure post offices with that threat into guilty pleas on false accounting in return for dropping the theft charges. Harried, sometimes, I'm sorry to say, inadequate defence solicitors and barristers encouraged and sometimes pressured their own clients into guilty pleas. They were told often they were technically guilty of false accounting when there was a strong argument they were not guilty. There wasn't actually dishonesty. Prosecutions were run by the Post Office using an expert witness who was handled by prosecution lawyers in ways that discouraged candour and independence. The lawyers also improperly influenced the evidence before the court. And in 2013, Post Office was secretly advised by their own lawyers this evidence was misleading and the expert unreliable or tainted, to use the phrase one lawyer used. They didn't disclose this until 2020, when they should have disclosed it almost straight away. Why not? Well, these prosecutions were marked by a kind of corporate evangelism. The postmasters were labelled thieves, and the system needed to be defended at all costs. And there was a commercial imperative. Recoveries from prosecutions were actually rather cheap debt collection. The corporate culture fed what social psychologists call moral disengagement. Harsh prosecutions may have been subconsciously rationalised because these postmasters were thought of as thieves and liars. Rather than get proper independent evidence of the robustness of the system, Post Office and its lawyers fed on cycles of confirmation bias. They believed the system was robust, and successful prosecutions confirmed that robustness without the evidence, really. Court wins reinforced overconfidence in their slanted version of reality. Now, we've only found out relatively recently they actually lost a good proportion of cases, albeit probably less than about 10%, but those cases were ignored or buried. Typically, they discontinued or settled them, and those files were never disclosed. Sometimes there were non-disclosure agreements. The lack of evidence on losses, on dishonesty, on the robustness of the system was a product of convenience and lazy incompetence. Lawyers didn't properly review files before charging to consider evidence. They didn't consider the proper tests for charging, and so on. The expert was not properly advised on his duties to the court, it seems, because the lawyers involved didn't understand or didn't want to understand what the court rules required of them. The fact the expert worked for Fujitsu, who ran the faulty system, did not excite serious concern at what was in fact a terrible conflict of interest. It is perhaps unsurprising, therefore, that Post Office and Fujitsu excused, qualified, or ignored evidence of problems that existed in the system and resisted disclosure of those systems as they should not have done. This was a mixture of error, self-serving interpretation of disclosure rules, and probably impropriety, refusing disclosure on grounds that could not be supported at the time, still less since. In the leading civil case, the Bates case, for those of you who followed the story, the lawyers talked openly with their client about improperly suppressing evidence. That was the language they used, saying they could hold out until they got rumbled, and then they would just concede and give the disclosure if forced to. And this points, I think, to an interesting recognition that such tactics were tolerated by the courts. Yeah? Indeed, in criminal cases, the courts waved away defence requests for disclosure and missed problems with the expert evidence, which would have been apparent on their face. We now know, only very recently, one former director of public prosecutions, so the head of the public prosecution system, has recently gone on record to say he reviewed files that showed judges sometimes had let postmasters down. The Lady Chief Justice has denied judges did anything wrong, but hadn't heard about this evidence. What all this meant was critical evidence was withheld from defendants and their lawyers for years. Post Office lawyers also abused legal professional privilege and showed themselves unable or unwilling to take any of their public interest obligations as lawyers, let alone as prosecutors, at all seriously. This culture of sometimes deliberate gaming of the rules and manipulative and misleading communication with opponents and even the courts continued into the next phase of the scandal. And I call this phase the containment phase. It was the point at which they came under pressure from the press and politicians, about 2009 in the story. It was marked by independent reviews conducted by supposedly independent lawyers in private practice. It was during this phase that the CEO said there was no evidence to suggest unsafe convictions in 2015. But Parliament were not the only ones misled. The courts were misled too, by witnesses and, it seems very likely, by lawyers. there was a team firm of lawyers who'd conducted prosecutions for the Post Office. They were then asked to review those same prosecutions and others for the Post Office to check that they were safe. They were marking their own homework. Seems extraordinary now. A leading KC, he had been the most senior prosecutor in the country, Treasury Counsel, was called in to review their review. In spite of a number of very clear problems in the review itself, including this conflict of interest, he said the review was, quotes, fundamentally sound, when it was anything but. It was, I would say, riddled with problems. There were other problems too. Both the KC and the solicitors firm failed to investigate why the Post Office's expert had misled the court. If they had investigated, they'd have found out that the lawyers from the solicitors firm had been part of the problem, but they didn't. They say now they can't remember why they didn't investigate. But there is an evidence suggestion that they may have been discouraged from looking into that as a bit awkward for the client. They also cannot explain why they did not require disclosure of their own assessments of that witness as unsound or tainted. They both admit now that they ought to have done so. Advice incredibly helpful to the client at the time, they now portray as mere human error. Everybody's human, one of the very senior barristers said. These decisions take place in the context of a computer system that all the computer engineers I talk to tell me none of the lawyers understood. That lack of understanding did not stop them taking advantage of any legal presumptions around the evidence relating to that system, nor did it prevent them on occasion confabulating reasons why an error could not have happened, or why disclosure should not be made because the computer didn't work like that, so we don't need to disclose it. They didn't know. These problems began to be first exposed in the litigation before Mr. Justice Fraser, the famous Bates case of the ITV drama, if you've seen it. I don't know what station it was on here. Yeah, I think it was on here. During the case that the judge eventually described as flat earth in its quality, Post Office, it's an absolutely extraordinary, it's 2 PhDs long, there are 2 judgments, if you want to read it, take you about a week. Post Office instructed very senior lawyers, including a former Supreme Court president, to try to provide advice on and then to have that judge removed for bias. If they didn't do that, the lawyers said, they would lose the case. Unsurprisingly, they lost the case, but not before a Court of Appeal judge had described their approach to that application to recuse the judge as both egregious and misleading. That was taken by Lord Grabbanner, KC. Let me conclude. What best describes what we see here, ethical recklessness and incompetence, I would sometimes call strategic incompetence, the lawyers paying attention to what the client wants without understanding or attending to the professional obligations that should have inhibited them. And it so happens there is a perfect Australian word for this phenomena. Sure. I did use this before I came to Australia, I hasten to add. Shonky perfectly describes what's going on here. There is evidence that suggests this was sometimes done cynically or deliberately, and sometimes it was simply an error, but an error driven by incompetence, or, as I say, strategic incompetence. Sometimes there were cultures of mutual irresponsibility. I advise and the client decides, the lawyer says, and the client says, the lawyer told me I had to do it. I had no choice. Mutual irresponsibility. No one is responsible. And privilege, of course, legal professional privilege, usually prevents that real position being exposed. Very convenient. But the inquiry has exposed it. Many lawyers, here's a sample, have been, here's another sample, been cross-examined. They show a number of times what I call the professional imaginarium. Lawyers think of themselves as professionals, but there's really interesting research that shows that lulls them into a false sense of security, complacency, or what the psychologists call moral licensing. And in the inquiry, they often said they couldn't really remember what had happened, but what they would have done was X. And then they describe their routine in professionally defensible, sometimes impeccable, terms. They've had time to prepare, of course. They are then exposed to the documents, which they have read during their preparation, which shows them behaving otherwise. Sometimes behaviour was questionable, sometimes it was very plainly improper. One barrister, shown to have improperly influenced expert evidence, issued a rather profuse apology. I've just given you a snippet here to the inquiry, having realised the picture he had painted initially was much rosier, he said, totally indefensible, I would say, than the actual evidence showed. But this was actually rather rare. Much more common was a lack of recollection, the suggestion that criticism might have been produced with hindsight, or was some other lawyer's fault. Nearly always another lawyer, actually, not the client, or was an honest mistake. Those were basically the range of responses. They relied on the orthodoxy, too, of certain tactics, document retention policies that conceal adverse evidence, the application of legal professional privilege as routine, a blind eye test being applied to evidence, and advice to the client not to investigate problematic matters for fear that they would find out that those problematic matters were indeed problematic. In a culture poisoned, I would say, by adversarialism and venality, such orthodoxies became awful orthodoxies. They led to professional misconduct, and in some cases, they may even lead to criminal prosecution for perverting the course of justice. Several lawyers were given self-incrimination warnings at the inquiry, and some, I am now told, are being investigated by the police. The professional regulators are also investigating for discipline. I can take you, the culture is one that is bought and sold in today's market for professional services, elite services and otherwise. I can take you to web profiles that show, and I'm going to show you two, lawyers selling their services as steamrollers who destroy the opposition, and masters of turning refuse into gold. He turns a pile of refuse into something that looks great. It's an absolute art form. These are two quotes selling services of two of the KCs involved in the case. One of those KCs was involved in that misleading and egregious application. In fact, he made it. What lay people would call these two quotes would be, I think, bullying and dishonesty. We might quibble about whether dishonesty is totally fair, but that's how they would say it. Lawyers see that as selling top-drawer lawyering. The Post Office case shows what happens when this gets out of hand. And of course, in this case, it led to hundreds, possibly thousands of miscarriages of justice. Just to give you a flavour, 10,000 people have now made claims for compensation. 10,000. And upwards of 11 people are believed to have ended their lives. A very large part of this problem was because lawyers could not say no. Actually, it was worse than that. They couldn't even recognise that they ought to have been saying no sometimes. These factors were part of the problem. Thank you very much.
Thank you so much for that, Richard. It's a privilege to hear your analysis of that, and we can see the passion that you bring to it. I want to thank you for your work on it. It's very difficult work, and you've been doing it for a long time. As someone who regulates the profession in Victoria and sees more of the worst of the profession than we'd like to, it's not always good for the soul, but it's important work, so thank you, Richard. We've got the opportunity now to hear from our panellists, and I was struck, as I'm sure many of you were, listening to Richard about the disturbing parallels between our own scandal here, the robo-debt scandal. Yee-Fui, you are an expert in this particular matter, so I'm interested to hear from you about that and the parallels that you see, perhaps including reflections on what brought it about.
Yeah, sure. So thank you, Richard, for the terrible, well, not terrible, but yeah, for telling us about the scandal in the UK. So we've got our own homegrown scandal, of course, the robo-debt scandal. And just a quick reminder, this is where the Social Security automated system, RoboDebt, erroneously identified overpayments for 470,000 people. And desperate people were ringing Centrelink. They were put on hold for 8 hours. There were terrible repercussions from that as well. A lot of mental health issues. Some people committed suicide as well. So there was a great toll, and we saw that toll in the UK as well, that great mental toll that happened because of these scandals. And yeah, those incorrect debt calculations were challenged. In 2019, the federal court held that the basis for raising debts under RoboDebt was irrational and therefore unlawful. And there was a settlement of a class action on behalf of 470,000 people, where the government said that they didn't admit any liability, but they were going to pay it out and stop using that income averaging method that was known to be not accurate for Social Security beneficiaries who receive fluctuating income. You can't just average their income. And another parallel is what the judge said about the scandal, that it's a very sorry chapter in Australian public administration. And the RoboDebt Royal Commission, the commissioner said that this is an extraordinary saga of venality, incompetence, and cowardice. So it actually mirrors exactly what you were saying about the post office scandal. Another thing is that, so I've got a term for that. You've got shonky, I've got omni-shambles. So these two omni-shambles, everything went wrong. But for it to go so wrong, there's deliberate choices made at key decision points. In Australia, it was the ministers, the public servants, the ministerial advisors. They put into place this scheme that they knew from the beginning was actually not going to be an accurate way of calculating the debts. And although the legal advice they got was from 2014 or said that this scheme is likely to be unlawful, they persisted for years, and it's only in 2019 that the scheme was discontinued. And in that time, hundreds and thousands of people were harmed. And yeah, we see another parallel there, that the government used those, you said aggressive litigation tactics. In Australia, it was kind of aggressive all around as well. So the media, the social security recipients who complained, the ministers and ministerial advisors smeared their names in the media, leaked all these bad things about them in the media. So it wasn't just litigation, it was smearing people who dared to complain. But yeah, there were litigation tactics as well, settling things so they don't go to judgment, having just draft advice, don't finalize the advice, things like that. And the positive story and part of Joel's story is that fight back after the scandal, that the civil society groups and legal aid fought back to fight this unlawful government decisions. And I think, yeah, you see that kind of parallel in the UK as well. The subpostmasters for justice, they band together. They look to fight the illegal government decision. And in the UK, they went one step further, and Media Star, BBC show that exposes this to the public. So there's that, yeah, really wrongful decisions, but also that fight back. I think that's the positive side of the story.
Thank you. That's a really great overview. Joel, we'll come to you in a moment, but I thought I might just reflect from the regulator's perspective on why we think this matters. You see, I think, in both the RoboDebt and the Post Office Horizon matter, obviously lack of professional independence and failures in integrity and disclosure, and then just really bad lawyering. But I think the thing that really is striking to me, and for the purposes of our discussion tonight, important is this failure to have regard to the paramount duty that lawyers have to the court and to the administration of justice, or to the rule of law as it's sometimes expressed. It's a fundamental duty. It goes above and beyond the duty that lawyers have to their clients, and it is concerning to me that the number of lawyers that confuse that and think that they have an obligation to do anything for their client. That's not the case, and indeed this obligation to the administration of justice is really a touchstone and one that lawyers need to return to when they are under the inevitable ethical pressures that will arise when you do the work. It's also, for me, plays into an interesting discussion that we have in my office as well about this tension where whether a lawyer should be advising a client simply about what they can do, but also about what they should do. So what's a lawyer's responsibility to provide advice that goes beyond being merely technically legally competent, but also what are the ethical or moral judgments, or perhaps simply the ethical or moral points that they should be making for their clients to consider, because we don't want to get into the situation that Richard outlined where the lawyer says, I'm just providing the advice, and the client says, well, the lawyer told me to do it. So it's important as well to be really clear as the lawyer that you're explaining to the client not just the technical legal outcome that might be possible, but also the broader implications of particular choices that a client might make. When the lawyers are working in public bodies with duties to act in the public interest, or whether they're working in companies or for-purpose organisations that need to protect their reputational social licence, these are really live issues that lawyers need to be grappling with. I think particularly challenging in an in-house environment where a lawyer can be quite isolated, particularly if they're just a sole in-house counsel. But as Robo-Debt and the Post Office Horizon show, that groupthink that can happen, the need to reinforce the norms of the legal team, the pressure indeed that a legal team can be placed under by their client, their employer. These are real challenges that we see that lawyers make. There has been an increase in the number of in-house lawyers in Victoria. They've doubled in the past decade. Nearly 30% of practicing certificates that we issued in 24-25 were issued to in-house lawyers. That's a good thing. It's very satisfying work. I did it myself, and it can often provide some flexibility, a different type of lawyering, a chance to really understand your client and the business, and if, in my case, working for a for-purpose org, a real sense of contribution to a bigger mission. But as I've said, there are distinct pressures that in-house lawyers can experience. We've got a piece of work underway at the moment to focus on identifying areas where there needs to be additional support and guidance for in-house lawyers, and that's included a range of targeted consultations we've run this year with the profession and its representatives, as well as other interested stakeholders. So really wanting to understand in detail the challenges that exist for in-house lawyers, ways to support them better, and then possible improvements to the regulatory framework in response to that. So if you're interested in that, which I assume you all are because you're in the room tonight, stay tuned. So Joel, over to you. Would you like to reflect a little bit on legal aid's role in Robo-Debt, and then also what emerges in thinking about the role of lawyers in providing legal assistance to people affected by these scandals, which is something that you're very familiar with?
Yeah, absolutely. Thanks, Fiona. Yeah, I mean, look, I'm a bit of a romantic when it comes to thinking about legal aid, and I think I've always thought that it is a marker of our commitment to the rule of law as a society that we have public funding going to a body like Victoria Legal Aid and equivalent bodies around the country, which are tasked to challenge the decisions of the very government which are funding them. And so that is a remarkable and, for me, quite a moving thing. But it's also something which has been recognised by the Productivity Commission as being an efficiency gain. for our society. The Productivity Commission has recognised that doing one-on-one casework in particular sometimes can be a very costly way of resolving legal problems. And we've heard about how in the context of both the post office scandal and robo-debt, central government picked off cases one by one to avoid dealing with the larger systemic issues. And so the Productivity Commission in 2014 said, look, there's real value in systemic advocacy, in trying to respond to the big picture issue, which is the overarching issue for this each of these scandals. So at Legal Aid, we early on tried to identify a test case and to underline how significant this systemic advocacy work is. We had to overcome exactly what Yee-Fui outlined, that there was an approach to litigation on the part of the Commonwealth Government which was designed to avoid an ultimate adjudication on the lawfulness of robo-debt. So I won't take you into the minutiae of the way that merits review works in Australia, but there are non-public merits review decisions coming out regularly through the course of robo-debt, and they are never appealed by the Commonwealth. They never take them to the public second tier of our tribunal. When we at Legal Aid issued proceedings on behalf of Madeleine Masterton, the Commonwealth zeroed out her debt and went to court to say there was no longer a matter which the court could deal with for the purposes of reaching a decision on the lawfulness of robo-debt. So there was a concerted effort to avoid adjudication. I mean, I see some parallels in what happened, in the post office scandal with the reliance on accounts as the means of proving liability for people affected by the scandal, to avoid digging in on the question of whether this Horizon system was giving true data about what had gone on at these post offices. So, all of that is to say, I'm a great believer in systemic advocacy as a core part of the work of legal aid bodies. It's also an important part of the work of community legal centres like Monash Law Clinics, but many other community legal centres around the country. And I think it's really important that we defend the place of systemic advocacy as part of the work of the legal assistance sector. From time to time there are political critiques of systemic advocacy because it's seen as the work of the legal assistance sector to help the individual punter, to help the individual facing a legal problem. That is undoubtedly a part of the work of the sector, but I think that we need to defend the place of systemic advocacy. But there is a trade-off there, and we need to be careful. I say we as somebody who runs a community legal centre, we need to be careful as a sector that we don't take the licence to do systemic advocacy to become party political campaigning organisations. If we're going to be involved in underpinning the rule of law, we need to be really mindful of the fact that we are serving the whole of the community in doing that systemic advocacy. So really careful thought needs to go into choosing your battles. My view is robo-debt was a very good battle to pick, though.
I don't think anyone's going to disagree with that, Joel. So, Richard, what do we learn from these scandals about the risks that can crystallise when in-house legal teams don't provide frank and fearless advice?
So there's quite a few things going on in the in-house side of the coin. I would preface my answer by saying, in some ways, the most egregious problems later on were led by the outside lawyers, actually. But when the problem blew up in 2013, the General Counsel she was called Susan Crichton. She was having pressure applied to her. Actually, it was one of the few occasions when you could sort of see what was going on in the evidence. She was an M&A lawyer. She was not a litigator, and she was having to deal with a litigation problem, which is about criminal litigation, to make it worse for her. She didn't get on top of it. She relied on others, some of whom were probably not very competent themselves, some of whom were playing the odds, I suppose. So she got into incredibly hot water there. So that was the first problem, sort of incompetence. The second problem was she didn't have she didn't know how to manage independent investigations, and she didn't understand or have a proper relationship with the board. So she couldn't. She was actually excluded from the board at the last minute when she was supposed to disclose information about the expert witness problem. Her written report also downplayed the problem, so it sanitized the problem for the board rather than explaining in clear terms, these are the risks here, this is what's really going on. So it's that sanitization, lack of access, and incompetence.
You mentioned the role of the external lawyers as well. What are the lessons there from the barristers and solicitors?
Well, they picked their horses, so they spent quite a bit of time vetting people, checking whether they were small p politically suitable, whatever that meant, and it probably meant that they would take the line that they wanted them to take. That was inappropriate. They picked people who were going to kind of support the party line and be aggressive, maybe. But again, they had a young. He was a 5-year called associate in a sort of medium-sized provincial firm, so Southampton, if people know the UK, and he saw a kind of golden ticket to partnership is sort of the subtext. We don't know that for definite, and he started to run the show kind of extraordinarily because nobody else was, or because Post Office wanted somebody to, and he was the person that the firm they'd instructed put forward. And so he was, again, inexperienced, looking for promotion to partnership, and took a kind of what looks now like a recklessly aggressive approach to lots of issues. And just saw that as part of the culture. So it was him that was part of this email chain that said, oh, we can just suppress the evidence even though we haven't got a legitimate reason, and this sort of thing. And that was an exchange partly with a trainee he was training. So this is what the trainee was being acculturated to. It's kind of extraordinary. This sort of immature adversarialism, I'd call it.
Thanks. So a feature of both of the cases we're considering tonight was the role of some kind of automated technology to help make the decision or to do the processing, whether it was the accounting system or the debt generating system. If we talk to us a little bit about how it is that these blunders in automated decision making come about.
Yeah, sure. And the first thing to say is that governments and organizations are very keen to use AI and automated decision making. It's sexy, so they get very evangelical about using it and rolling it out. But the problem is that they don't think very hard about what they're actually doing and the impact of what they're doing. So what we saw in RoboDebt was a combination of ideology. So the minister responsible, Morrison, who then became prime minister, called himself a welfare cop. So it's this idea that we have to punish welfare recipients, their dough bludgers, that kind of terminology was used. And we have to get all these overpayments due to them, which were all wrongful. And the design stage was flawed, as in they knew that income averaging wasn't going to be the correct methodology, but there was this decision based on ideology that they will push ahead and try to recoup this money. This is part of a broader trend that is called the digital welfare state, where Philip Alston in the US, the former UN Special Rapporteur, said that it's where digital data and technologies are used to automate, predict, surveil, detect, target, and punish. So this is actually quite a punitive thing. And you don't see governments rolling out these automated systems on to predict insider trading by the wealthy. It's always on social security recipients. So, the RoboDebt blunder was caused by this blind ideology where they wanted to punish social security recipients and target them. But also that idea of cost saving, we're going to save money by doing this. But the ironic thing is that because of all those payouts, because of litigation and all that, the scheme actually ended up costing the Australian government $565 million. So it actually cost the government to have put out this really wrongful scheme. In terms of the Post Office Limited is a wholly owned government company, and you set up such a structure if you want some level of independence from government, but not too much. So it's kind of in a vexed position. And the Post Office executives clearly took a decision to pursue, as you said, aggressively pursue these sub-postmasters at all costs. And yeah, you have to question in terms of government-owned corporations, what is the level of accountability? How independent should they be? And how do you hold those executives accountable? And we saw in Australia as well, the ministers and public servants and ministerial advisors, sure, they were asked to appear before the Royal Commission, but a lot of them are on very well-paid, lucrative positions after Robodebt. It's not like they got actually punished by this. So yeah, there were multiple causes of the blunders, but we are still seeing the repercussions flow through. And same for the UK, the inquiry is continuing.
Thank you. So we're going to have some time for questions in a moment, so I'm just giving you a warning so that you can start to prepare your questions, so there won't be that awkward pause when I say, does anyone have a question? But we might just talk a little bit more at the panel level about this, moves to using artificial intelligence, generative AI and automation to help make government processes more efficient, and sometimes also to assist with decision making. Perhaps to all of you, maybe with you first, Joel, and then back around. What do you think are the things that we need to be really aware of for Live 2 when we're thinking about that based on your experience?
Yeah, well, I mean, one of the things to say certainly about Robodebt is that it was not a sophisticated AI system. It was not a sophisticated system at all, and nor obviously was the Horizon system. So it may be that there are different considerations which need to be brought to bear if we're talking about a true AI system. But I think whatever automated system you're talking about, one of the things you need to remember if you're doing high volume decision making using an automated system is that you're doing default setting. And this is one of the things that was very much part of Robodebt, that it set a default that unless a disadvantaged member of the community actively sought to engage with government to overturn a preliminary decision from government, then they were going to be saddled with the debt which was generated using the Robodebt system. And so if you're using an automated system, one of the real pitfalls of high volume decision making processes is you can set defaults which can then put people on a particular path, and they may not have the legal capability to reset the course of their life. And in Robodebt it was about social security. Obviously people in the context of the post office scandal found it very difficult. Most of the lawyers found it very difficult to unpick the Horizon system and understand what was going on. So it's really important to be mindful of the power of default setting using these systems.
Thanks, Joel.
Yeah, so how do we stop scandals like this happening again? So my book proposes actually 3 different levers of control, like legal controls, political controls, and managerial controls. So by the time you get to litigation, it's actually too late. Hundreds of thousands of people have already been harmed. So what is needed is a lot of reflection earlier in the stage. So when governments are thinking of rolling out these technologies at the design phase, I think there should be managerial controls within the government department and agency and the post office to undertake a impact assessment, risk assessment, participatory processes with people who are affected by the technology. So they have to think really hard at the design phase before they roll it out and everything goes omni-shambles again. So my argument is that they have to start much earlier in the piece, before they roll out the technology, and put in the controls at that point. And that should stop things from going horribly wrong down the track, hopefully. So yeah, that's my proposal.
Thank you. And Richard, anything to add to that?
Not a great deal. No, I think it's thinking about where the risk falls, thinking about whether it's possible to find out what happened, which was a real problem with Horizon, even though it wasn't a complicated system. It was kind of closed without, even to the experts, it was pretty closed. And having systems of investigation and support that properly get to the root of problems kind of independently of the people who are running the system. Now, that's quite expensive, but those are the sorts of things that need to be somehow factored into the systems. Otherwise, risk will just be shifted to the people who can't investigate or fight, and we will have more robo-debts and more post office scandals.
Thank you. Yeah, I think it's... as someone who, is a government administrator, as part of my role, there's always pressure to do more and to do it more effectively, and demand increases. And so you're thinking about ways that you can be more efficient, and also thinking about your staff and trying to alleviate administrative burden from them. And I think we've been exploring in our office whether there's potential to use some generative AI tools in the way we do our work. But we've taken a very deliberate decision to hasten slowly and to spend quite a bit of time thinking very deeply about how we might want to do that, and in particular investing in the development of an artificial intelligence framework. So before we do anything at all in that space, having a strategy, so articulating our understanding of this technology, what we would want to use it for, importantly an assurance framework, excuse me, so making sure that we are using it ethically and that we've got the appropriate checks and balances in place to be able to use it properly, and then working on the delivery approach, articulating the kinds of areas in our work where we think it might apply, identifying some use cases which we can then pilot and test, all of this in a kind of closed environment, if you like, until we're very confident that we've got the frameworks in place and the skills and the capability to be able to use it. Even there, it's unlikely, I think, that we'll be using it to make decisions, rather to help us analyse the information and data that we have. I think it's clear that from what we've talked about, that transparency is so critical, not just transparency to see what's happening in real time, but also to be able to go back and explain what has happened and how decisions have been made. That's really fundamental for people's confidence in these systems, and also obviously the ability for people to challenge them. There's a few thoughts. We've also put out, if anyone, again, if people are interested in AI and the law, we've got a joint statement that we issued with some other regulators in the legal space on our website, and we're doing some more work to provide some guidance to lawyers, which will be out later in the year.
My great thanks to the panel for their insights, their reflections, and again, happy birthday to Yee-Fui, and I look forward to carrying on the conversation in a moment's time. Thank you.